Yeah, so you're all here because you're basically interested in how to do co-production, and I mean, all of you guys, I guess, have been developing games in the past, so you know that already doing that alone is a huge coordinational effort because you have to bring together the team, you have to coordinate all the individual departments in working together, and I can just tell you from my experience with several co-productions, it doesn't get easier when you have to coordinate two or more teams in doing the game development. So basically, the question is, how do I structure a co-development? And I've tried to structure it a little bit. So these are not standing terms. It's just how I try to bring it closer to you, how you can structure such cooperation. And on the one hand, it's what we call a co-financing deal. And in a co-financing deal, we have two or more parties that actually have agreed to pool an existing budget and have agreed on a project that they want to finance. But the key in a co-financing deal is that there is one party of this co-financing that is in the lead of development. So there's one core developer who is responsible for the development, and this core developer also is in the end the owner of the exploitation rights, and the co-finances um, will usually not be granted their own exploitation rights, but they are simply participating in the revenue that is realized by the developer responsible for the main production. So this can be a pure financial contribution, but it can also be a development contribution. So instead of contributing, let's say, 500K to the production budget, it is also possible that a second development studio um, um, is delaying their payment for services provided to the production, and instead of getting a fixed fee or time and material remuneration, they will receive a revenue share from the exploitation of the game. So this can either be a purely financial issue, but it can also be a co-financing by bartering services. Um, the key again is that we have one studio that is in the lead of the production, and all other participants in this co-financing are simply providing either money or services to this main producer of the game, the main developer. And then we have what I would call the real co-production, um, and the real co-production works a little bit different. And there we have, again, two or more parties. Yeah, we always need at least two parties. And there the goal is to develop the game together. So there's not one party that is in the lead and decides on what will happen to the game, what will happen to the exploitation, but all parties decide together, and they work together in a parted way where each party provides their own part of the game towards the complete production. So basically, in the end, the game is also co-owned by all co-producers, or at least partially or initially, and you will see later on, rights are usually assigned to individual partners, but in the beginning at least, the game is owned jointly by all co-producers. So that is a basic difference between um, what I call the co-financing deal and the co-production deal. Um, Both, however, is something that is basically interesting to any of you who wants to cooperate with another studio. And I will show you on the other slides uh, how these structures differ and what advantages or disadvantages they have. So basically with the co-financing, um, it is very easy to also integrate third-party investors. So even if you're two development studios, but you can't shoulder the whole production budget in a co-financing deal, it's very, very easy to integrate external investors that only bring money to the table. Because in the end, all you need to discuss is a revenue waterfall, because the rights in the game will remain with the main developer. Basically, what you need is a revenue waterfall, and there are several mechanisms you can use to bring money into the production. For instance, a royalty-bearing loan. The investors or the co-financers bring money in and they earn a royalty share instead of a repayment of the loan, or a silent partnership, which means that they become an internal partner without voting rights, but with profit participation. Um, or even what is possible is that a co-financing happens by the investor purchasing an actual share in your development company. Or if you're working with a co-developing developer, you could even exchange shares so that each of you participates in the other party. So these are all possible ways how to integrate these. So if you're talking about a co-developer, um, those can usually also be a co-financer without any cash contribution. That's what I said before. So let's say you have one developer who's very experienced in developing car movement systems or driving algorithms or anything like that, then they could, for instance, provide the middleware for the calculation of the car direction for the game, while the other developer develops the normal movement, and the remuneration then is not paid uh, like you would usually do with an outsourcing party upon delivery, but they would then earn a revenue share from the exploitation of the game. Um, as I said before, the core is that all rights vest with the main developer. They are in the center. So if one of the co-financiers actually quit the production, there is no problem uh, as far as the rights are concerned, because the rights are still centered with one developer. Um, what I've seen in the past is that you could also, instead of assigning a revenue share, you could also assign individual rights to a co-financer. So, for instance, we had the case where there was like a co-production from Europe and Korea, and the Korean co-developer um, was assigned the distribution rights for Korea, China, and Japan instead of any revenue share payment. So this also is an option that you can go in a co-financing. Um, so this is something that might be interesting. Um, so basically, in the co-financing, we all reduce it to how the co-financer is paid for his financial or service contribution, but he's not the owner of the project. From a legal point of view, the co-financing has one big advantage, that it's very easy to structure, because the structuring can be done based on very, very traditional um, production or financing agreements that are used in the business since many years. So the only difference is that we're not talking about standard development agreement, but that the remuneration is modified. All the other issues are very traditionally built. So co-financing is, from the legal side, very easy, and it's very close to traditional outsourcing or investment deals. Um, Also, the co-financing has one significant advantage, and that is taxation. As you'll see when we talk about the actual co-productions, co-productions always have taxation issues because in many countries, a co-production is considered a partnership. And once it is considered a partnership, that will result in the requirement of a common tax declaration, and also that you suddenly have as a partnership offices in other countries. Like if one developer is from Germany, the other from France, then suddenly you have offices in both countries, and you'll have tax authorities in both countries asking for tax declarations. This is something that does not happen in a co-financing deal because there we have a very traditional non-partnership based structure. Um, so the also the one advantage is that the main developer could even engage other investors like publishers or VC investors without having any problems in the structure because he is still the owner of the rights. He can decide, and nothing that he does will influence or reduce the participation of the co-development partner here. Um, the obvious disadvantage is that is also one of the advantages. The disadvantage is that your co-financing partner, your other development studio, might feel the fifth wheel on the car because they are only providing services. They don't own the product. They might not be as involved as you might want them to be, because there is just one party that holds all the reins, and the other one is just getting a revenue share. So this might be a significant disadvantage of this model, and also the co-financer does not usually receive any rights in the production, which also might be a major setback in the negotiations. Um, so let's switch over to the actual or the real co-production, and there basically are three typical structures for co-production. And just for you to understand, I'm trying to explain this from a very abstract legal point of view because this might differ from country to country, specifically if we're talking about partnerships. Um, in each country, partnerships are regulated a little bit different. So I will try to keep it very general on a general level that might apply to most countries, but understand that this might differ based on where you are and where your co-production partner is. Um, so the three common approaches to co-production is either a partnership, registered or unregistered. It could be a formal joint venture, which means that we actually set up a company jointly owned by both parties. Um, or we can try to set up a co-production in a cooperation structure that tries to avoid a joint operation. Um, why is this C a relevant issue? And that's what I already started to talk about. It's a taxation, because once we have a partnership or a formal joint venture, we will have to face taxation issues in both countries, and also where the joint venture obviously is based. And the only way to avoid that is to avoid a illegal joint operation. And I will try to show you how that can be achieved, but it's a dance on razor's edge. Um, in a partnership, basically both partners form a legal entity, and in most jurisdictions, there's not even the requirement for a formal foundation act. So, for instance, in Germany and other European countries, if two companies decide to work together on one project and they commit funds to that and they agree that they'll both be the owner of the results, then it basically is founding a partnership. Um, and usually it's also called in some countries a partnership under civil law or under civil rights, and it comes automatically by cooperating for a common purpose. And in such a partnership, usually in most jurisdictions, both parties are equal partners and decisions are made unanimously. So there is at least in many jurisdictions, there is no rule of majority, but all partners, which can be two, three, four, five, have to decide on all business decisions unanimously, unless you have a contract that states how decisions are made. So that might be a good idea to have some mechanisms how you want to do the decisions in the company. And unless you have any different agreement in place, unless you have a different shareholder agreement in place, all assets, all rights, all revenues are all co-owned jointly by all co-producers. So using that money for anything will always require the approval of all co-producers. So that is basically the situation, unless you have a different contract in place. And also relevant, in a partnership, all partners are usually fully liable for the debts of the partnership. So there is no limitation in liability in civil partnerships. That might also be relevant for many who decide to cooperate, that once you go for that way, you are fully liable for whatever happens in that partnership. And that might be a little bit too much risk, especially if you have an established business. So you might want to consider if that is actually something you want to do. Um, if you go for the partnership, then it is best practice to pool the development funds on a joint account, because you'll want to make sure that payments are only made with in accordance with what both parties have decided, and it's easiest to control that if all development funds are on a controlled joint account. Then you also see that all monies are actually used in accordance with what you agreed for the development budget. Um, Sometimes, especially if no external partners are to be paid, it might also be sufficient to have a virtual account where you register each partner's costs for the respective month. But at least if external payments are made, this should be from a joint account so that everybody sees what money is spent for transparency reasons. You need to be very clear on who's supposed to do what in a co-production. And that's what I meant in the beginning when I said coordinating one team might be complicated. Start coordinating two teams. So not only you need to be on par on what the whole game is, but you also need to understand what each party has to deliver and how these parts will be put together to form one game. And if you set up a co-production, this is one of the first things you need to do, is to analyze what we'll have to do, what is the total budget, who does exactly what, and what are the quality and specifications requirements for both partners. Because otherwise, you'll end up in a situation we also had uh, several times in the past where the partners started developing, and after half the development time, they found out that they had a very different quality understanding of assets. Um, and since everybody just worked for himself for a time, they only found out after several months, and then this co-production actually blew off because they couldn't agree in that situation anymore on quality requirements and on cooperation procedures. So that's something that you need to discuss in the beginning of your co-production. What are the quality requirements? What are the technical requirements? Who has to deliver what? And I know you all will tell me that agile development makes that impossible. Believe me, you can also do that when working with agile development planning, as you need to have the common understanding who does what in the co-production. As I already mentioned, the partnership may cause issues like double taxation. So whenever you enter into a co-production based on a partnership scheme, you will need uh, good tax and finance advisors in both countries in order to prevent double taxation events. And they will give significant input on how to draft the respective agreements based on your national taxation laws. The other alternative is a joint venture. A joint venture means that we form an independent joint company with its own company identity that will do the production. And a typical structure is here forming a joint limited liability entity in one of the countries and providing the development funds to that entity, and then entering into development agreements with both shareholders. So this is basically a little bit like a mini publisher that outsources the development to two studios and finances the development for both studios. You could also try to finance the joint venture and recruit its own personnel for the joint venture, but usually for studios of your size, this would be a little bit too much of integration and financing raising. So the easiest process is form the joint venture, put the money into the joint venture, and then order the development with both partners and shareholders of the joint venture company. And then all rights are actually pooled in the joint venture company that is owned 50-50 or whatever share you decide on. This has one big advantage. The big advantage is taxation is clear. Taxation happens at the joint venture, so you can control where taxation actually happens, wherever the joint venture is based. You can potentially sell the whole project without influencing any of your own current developments or your own teams. And also you can get external financing in there without having anyone becoming a shareholder of your actual development company. So you have a lot more possibilities in a joint venture scenario without influencing anything at home. That is something that is a huge advantage of the joint venture, even though the disadvantage obviously is there is administrative efforts to set up a separate company. You need a director. You need to set up the necessary funding. You need articles of association, and all the stuff that comes along with setting up a new company. The other advantage of the joint venture is that's what I put in here. We can use traditional M&A or traditional investment-based agreements for a joint venture. So there is a huge stock of experience on how to set up joint venture companies, specifically in M&A situations. So it's something that that I would say that more attorneys have experience in than in setting up a game partnership. So the chance of getting qualified advice is higher. Um, in case of a joint venture, you need to agree on who will be at the board of directors. Usually, both parties will send a representative. You might also get one external that both parties agree on. We always advise that in a joint venture, accounting should be done by a neutral third-party accountant and not by the accountant of one of the parties, because this simply causes distrust. Um, and what also needs to be done is that you agree early on a scenario how to dissolve the joint venture should one party decide to stop. Again, this is something uh, that most people in corporate law should have significant experience in. Uh, I would just mention measures like reverse vesting scenarios that can be agreed for a joint venture. Um, and then the last alternative that I already mentioned is um, that you try to avoid any kind of joint company or joint partnership or joint venture. And that is when clearly assign um, you clearly assign responsibilities to each party. So, for instance, one party is responsible for game design, program the coding is responsible for the UI, and the other party is solely responsible for developing art assets, and each of the parties has the final say in each of their department. Then you're lacking the qualification as a partnership because there are no common decisions, but each party has separate authorities in the development. And if you're able to structure um, a development like that, where you have clearly distinct areas of responsibility, then in most jurisdictions, you will not be considered a partnership. You'll avoid the taxation issues, and you only then have to agree on who shall be authorized to exploit the game in the end and what the revenue shares are. Um, this is an approach that is very valid, but requires, uh, on the one hand, a significant level of trust, and on the other hand, a significant level of planning, because you need a common understanding what each party is supposed to do and how it is supposed to look like in the end. So these are the downsides of this approach, that you need a very deep level of project planning. We've done this before. For instance, one of these co-productions that have been structured like this has just entered early access on Steam. It's called Starbirds, if you want to have a look at it. That's a co-production between a traditional game developer and a successful YouTube channel, where the YouTube channel built the story and the graphics, and the game developer obviously designed the game mechanics and did the coding and the game design. So, but in that case, we applied this procedure, and they did really have a significant level of planning up ahead. The advantage is you have no costs for a joint entity. You don't need a common account because everyone takes care of its own costs. You don't need to overview what cost the other party spends once you have decided on who delivers what. It's their issue how much they actually spend in the end, because they have the share, and they get the share for delivering their part in the production, not for the costs they spent. Um, so yes, the advantage is no taxation problems, no additional overhead for for setting up a new company that is jointly controlled. But on the other hand, you have more overhead and planning in the beginning. Yeah. So basically, also just an advice that co-productions are entitled to public funding in many European states. So you could combine public funding from different states. That can be very interesting. And the locally available funding programs should be checked before you start the co-production, because usually, at least under the European law, you will not be entitled to funding if you've already started the project. So you need to apply before you officially begin the production, and only then you're entitled to funding. That is an issue that you have in many European states. So I've run through it now, and I feel my voice deteriorating further, but I hope that you at least got some idea of how the structures could be, and what would be necessary, even though it will differ from country to country, obviously. But my intention was just to show you ways to legally structure these. And I'm now happy if you have questions.
Thank you very much, Kai. I didn't see any questions yet in chat, but I'm assuming that also there was like a very in-depth and a lot of context and everything. So I'm going to leave a bit of time now. If anyone wants to open the mic, raise a hand, ask a very painful, direct question. Martin, go ahead.
Yeah, thanks for having me. One question just arose. You said the co-production type C, a structure that avoid legal operation. How would you describe is the difference to a co-financing deal?
Yeah, in a co-financing deal, you have one main owner of the game, which in the co-production with separated tasks does not necessarily has to be so. In a co-production with separate tasks, it's quite possible that both parties jointly own the result. Because jointly owning the result doesn't make a partnership as long as only one party is actually exploiting it. While in the co-financing, it's clear that one party is owning the results. So that's one of the major differences.
So, but in both ways, you would have to have some contracts in place to specify the ownership and also the.
You need that in all cases.
You need that
In
in
all
all
cases, you need to
cases. Yeah.
make sure who actually owns it. So yeah, you need to have a contractual basis for development and exploitation in any kind of co-production. Yeah.
So it is more of a terminology. We call it a co-production because we are then entitled to public funding programs.
And yes, and I can tell you that the public funding authorities have no idea what actually co-production is. And as long as you show them that you are cooperating on a certain level, that will be fine. At least in all countries that I've yet seen, they do not very much differentiate based on what kind of co-production or cooperation you do.
Or even if it's formally a co-financing deal.
Exactly. Yeah.
Okay. Yeah. Okay. Thank you.
Wonderful. There was a question in chat about so at some point you said the M&A
Yeah.
word. Could you develop on that, what exactly that means and what that entitles?
Yeah, it's mergers and acquisitions. So that's that part of legal where you acquire shares in other companies and sell them. That's a huge part of corporate law and legal advice whenever you do financing deals. And since M&A is such a general part of legal advice, you have a much broader base of experience and information and contract drafting than in the co-production of games, where you usually have not so many people being very experienced. So that's basically it. M&A means mergers and acquisitions.
Thanks. Any other questions, maybe directly from?
I do have a question. Hello, Kai. Thank you for the presentation. Um, there's this one thing that I always wanted to ask to lawyers about international contracts, because we always put like where the contract will be actually like I'm in Brazil, and the contract will apply to Brazilian laws, etc., etc. This kind of things. How does it work on these situations? I mean, how do I do this more even to both parts? I mean,
You
can
don't.
we?
It's easy. You don't. You can't make it even to both parts. I've seen attempts to do that, which were very sad. And for instance, I've seen a contract that stated that this contract shall be subject to the laws of the party that is suing the other party. That means that one contract should be supposed to the law of two different states, which means that whoever tries to make a claim might have a different result. That doesn't work. A contract can only be subject to one jurisdiction. That's it. It can't be for both of them. So you have to decide what jurisdiction a contract shall fall under. And usually you should have at least one attorney at the table who is experienced in the law of that country, so that you make sure that this contract actually works under that law. What you can do, but what I would not advise you to do, is you could, for instance, agree for let's say a Brazilian German co-production. You could say uh, that the contract is subject to German law, but you agree that the courts of Sao Paulo shall be responsible to solve any disputes. So that might feel more balanced, but have a closer look. What actually means that? It means that if you have a dispute, you would go to the courts of Sao Paulo, and the judges in Sao Paulo would have to decide what the contract means under German law. What do you think? How happy the judges in Brazil would be to decide a conflict under German law? So what would they do? They would say, I have no idea about German law. I've never studied it. So they will just go out there and get an expensive expert opinion from a German law firm. So what you do is you then have judges in Sao Paulo, but they would just go back and get an expert opinion from Germany that you have to pay. And I don't know if that's an advantage for fairness. So
Seems more complicated.
it is. So my advice is if you say um, I really need it to be Brazilian law, then okay, then it's Brazilian law and the courts of Sao Paulo. But if it's German law, then it should be the courts of somewhere in Germany, because those people are experienced in that, and it's just makes it more expensive and complicated otherwise.
Do you think that is fair? Let's put that way, like fair. If the jurisdiction of the contract is always on the weaker side. I mean, for Brazilians,
I
it's
don't
more
see
expensive to hire a lawyer in Europe or America. Like,
I don't see how the choice of law actually is something about fairness. Um, I mean, it might be if you choose the laws of Russia or let's say Saudi Arabia, then it actually means that court decisions can't be enforced outside of those countries because those court decisions are not accepted anywhere else. So that
yes.
might be unfair and not practical. Um, but in the end, I would rather say it's a matter of cost effectiveness.
Yeah.
Um, yeah, you can agree on English or on US law, but then you have to understand that simply by that choice, you have multiplied the costs of any kind of dispute by 10 or 100. For instance, comparing costs of a lawsuit from Germany to London, it's a factor of at least 3. Yeah, so it's much more expensive, and with the US, we're talking about a factor of 100 easily. So that might be a factor you can take into account, but fairness, at least as long as you are in countries with a working legal system, I don't see any fairness advantage.
Yeah. Okay, I got it. Thank you.
How would you decide, or how did you come up with these numbers? Which country is cheaper now?
Experience.
Is there something, some publication on that? Is Canada cheaper than Switzerland?
I cannot tell you that because I have no experience in Canada. I know how much Switzerland costs compared, for instance, to Germany. Um, it's based on 2 things. On the one hand, the cost of the court, and on the other hand, the costs of the attorneys. And it's quite easy. I mean, I'm working with colleagues in the US on a daily basis, and the colleagues in the US have an hourly fee of $650, and I have an hourly fee of $300. So calculate it on your own, and if you know how much more complicated the US legal system is in a court case, then you'll understand how I end up with a factor of up to 100.
There is a Canadian in chat, Eamon is saying that the lawyers of Canada are proud to say that how expensive the legal system is there. So
Yeah,
probably
it's funny
US style.
It's quite funny because in Europe, actually, the German legal system is quite cheap. Most expensive is the UK in Europe, and France is right in the middle.
Wow, here we are debating the prices of lawyer across the globe. I love it. Peter, go ahead. Switzerland. Sweden. How expensive is a lawyer in Sweden?
Not so bad.
You're muted, Peter. We can't hear you. You're muted. Peter.
Here we go.
Yes.
Thank you, Kai, for the presentation. Hopefully we are going to start co-production with a studio in South Africa. And yes, fingers crossed. And I just wondered, what's your experience with that jurisdiction, and what should we think about coming from being a European country or European studio or Swedish?
Yeah.
Is there anything special you have in top of your head?
Yeah, I don't have many experience with South Africa. I just had 1 or 2 deals with them, and that worked quite well. The South African legal system is very much based on the British legal system, with influence from Holland. So it's a little bit of a mix there. As you know, that we Europeans have a tendency to just believe that only EU members are trusting jurisdictions because it's so much easier for us. I mean, if I'm doing deals within the EU, I always know that I can enforce it somehow because within the EU it's quite easy to enforce claims. It is more complicated with countries outside of Europe, and what you always need to take care is, for instance, can you enforce court decisions from that country in Sweden or the other way around? And for South Africa, I can say yes, that's possible, but there are a lot of other countries where that's not possible. As I mentioned earlier,
Okay.
like Saudi Arabia or Russia or Iran, where court decisions cannot be enforced. So I've seen cases where Russian companies willingly accepted German law and German courts because they knew that if we sued them in Germany, we could never enforce it in Russia.
Okay.
So that's something that you should take care of before, but I've not heard of any major problems with South Africa.
Okay. Thank you.
You're welcome.
Nice. Anyone else having big questions or like already on the verge of co-productions that are between two specific countries and you would like to ask about it?
One more question from my side. I'm coming from software engineering, and we have that system. We call it open source, where we share common knowledge.
You don't need to explain open source to me.
Yeah. Does it exist in the legal? Do you know of repositories for contracts?
Yes, don't do that. But just yes, there are. It's Creative Commons there.
Yeah.
It's not open source, but Creative Commons. But I strongly advise against that
Why is
because most of those contracts you'll find on the internet are either of low quality, and they have not been tailored to your situation. And co-production agreements are very much individualized based on the individual requirements of the teams and what they intend to do. I've had situations where people came with those contracts, and they're a nice thing if you want to develop thoughts. So if you just look for them in order to have an idea how it could work, that's fine. But don't use it as a contractual basis. Go to someone who's experienced in game development as an attorney and have him or her draft the contracts individually based on the feedback you might have developed on what you found on the internet. But whatever you find on the internet will not cover the individual requirements of your co-production. And also, just because I've been heard so much in the last month, please don't go to any attorney and say, I've asked ChatGPT and I've got this document here. Please don't do that. It's the same like going to an artist and saying, hey, look, I've done this with OpenAI and it looks so great. Can you do something similar? It hurts.
Thank you for that answer.
Maybe quickly before jumping on Peter's question, that is exactly the reason why I also will not share with you any templates on a potential co-agreement, the pre-agreement that you might want to do and everything, because this is every time just not working, and you're going to take more time reading the documents of other people and figuring out that actually does not fit your situation at all. So just make a paper, send it to us, and kind of will have a look and be like, that's legit, or like just deep diving and adding elements here and there. But that's not a need so far. Peter, yeah. Muted again.
Speaking about open source, we are researching if we should use Godot or Unity as a game engine. And since Godot is open source, is there any particular issues with that legally? Can that be more complicated
No,
or
there's no issue with Godot, as the Godot engine is not subject to a traditional copyleft license. So we're not talking about a copyleft license, and therefore you have no legal issues with using the engine. It's fine. I would rather make it dependent on the technical abilities. Um, I mean, okay, obviously for Unity you need to pay a monthly fee, um, and you don't need to do that for Godot. But most teams, and that's what I advise, decide based on the technical options that the engine has. There's definitely no disadvantage of using the Godot engine.
good? Super, thanks.
Wonderful. Any other questions?
Doesn't
Big-
seem so.
Sounds like the big debates have been solved, yeah.
Yeah, and even if you have any questions when you go through your notes later or anything, then just drop me an email or send me a note on Discord. That's no problem at all. Stefano.
Yes, Stefano. Are there any specific issues to intercontinental co-productions? Common pitfalls?
No, it just depends on the individual countries. If it is Europe, Africa, Europe, South America, Europe, Asia, there's no dues. There can be no dues in individual countries, but not in intercontinental co-productions in itself.
In that case, Stefano, I don't know if you have any specific country in mind when you say intercontinental. You are from Bulgaria, so I'm assuming that you're thinking of someone in Brazil, Bulgaria, Brazil. That should be.
Based on my experience, Brazil is working just fine. And it's always a good place to go to for production meetings.
Fantastic. Luana is cheering for Brazil. Okay, good. Peter, the session is recorded. I will just try to see if the potato is not burning out and if I can have the recording tonight. If not, you will receive a link with the session a bit later. And I also have shared your email, Kai, in the chat. So if any one of you want to take it now, you can. If not, always send me an email and we can also like to figure this out together. But thank you very much, Kai. This is the right timing to also mention that you will be probably you or your colleague Igor coming to the workshop. In which case, this is the advertising time again for everyone. The official deadline for the matchmaking session is the 10th of October, meaning that after that time, I will not be able to support you as much as I am currently. Not meaning that you have to stop your conversation and just drop the ball completely. Simply that, like, if you are having a co-production that you think is becoming serious, you have a partner with who you want to commit and become a bit more serious on the side of the legal stuff, of the workflow and everything, and you would like to be supported, please shoot me an email before that so that I can include you in the workshop that we're going to have. As a reminder, it's going to be on the 30th of October during the Paris Games Week. And in the fees for the workshop, we actually include the tickets for Paris Game Week itself because we have the business area that's going to work out and we're going to spend a few days there. There is also a lot of panels and co-production specifically that are going to happen on the Friday, so you are welcome to join. If you really want to partake in the workshop, even though you might not have a very secured match, please contact me so that we can see it together if that makes sense or not on your situation, depending on the stage that you are in. But in any case, excited for everything. So you still have, let's say, roughly 15 days, maybe 3 weeks now, better, to converse with everyone else. And as soon as you have someone that you feel like you could collaborate with, please, like Kai mentioned, do not use a ChatGPT template to make a fake agreement, pre nuptial agreement, but just like send us everything that you have thought of, everything that you are planning for the next steps, and I will go to you to see also like together if I can help you sort things out, and we will see it all in person with Kai in Paris. So exciting.
Yes.
In the meantime, if you have one last word, Kai, to mention about the legal aspects of co-production, what would it be? Like the one thing, the stellar, the North Star that they have to keep on following when thinking legal.
The North Star for co-production always is that you talk a lot about what you want to do, that you are on the same page of your product and your individual tasks, and that you also discuss in advance what happens if one of the partners isn't able to perform anymore. So, on the one hand, be sure that you discuss the tasks of each partner, and on the other, discuss exit scenarios. And that is what I would say is the most important for all of you to understand, that it's very much about talking and thinking the project through.
Fantastic. Very clear. Thank you again very much, Kai. And see you everyone online or per email or on Discord. Good luck.
Great. Thanks, Lynn.
Thank you again for the presentation.
Yeah, bye-bye.
Bye, everyone. Cheers.
Thank you. Bye-bye.
Bye bye.
Have a good
Bye.
day.